Good morning, everyone in Europe, and good afternoon to all our spectators in mainland China and in the rest of the world. A heartily welcome to our webinar today, which is organized by CIETAC, by China Arbitration law firm and Wenner law firm, and in the framework of the China Arbitration Week, we will talk today with two different panels about how to resolve arbitration and mostly through virtual meetings in the time of COVID. We all know that Corona times make it a lot harder for everyone to travel, sometimes even to communicate. This also has an effect on the world of litigation, arbitration, and mediation. And today we're going to speak about which solutions exist, also which obstacles or difficulties you might encounter, to get you some help and some insights of how to best handle your arbitration and mediation in these difficult times. I would like to present you my first panel, which is composed of Mr. Christopher Chinn from China Arbitration. He's an American lawyer and also qualified as a European lawyer in England, Wales, and France. We also have Mr. Su Yang with us, who is the European head of CIETAC, which is based in Vienna. And also from Vienna, Ann-Karin Grill, she's arbitrator, mediator, qualified in Austria, but working very often in France and in other European countries. So somebody who's got a lot of insight, especially in the last months, of how to handle arbitrations. I just learned that she had a big mediation that she finalized last week. So it is possible to hold arbitrations and mediations even in COVID times. And I would like to give the floor directly to Mr. Chinn to give us a little bit the framework for our discussions today.
Thank you, Martin, and thank you, CIETAC, and all the speakers for joining us and putting together this webinar. We hope that it's a short webinar, but we hope that it'll last about 2 hours. But we hope that you'll find it informative and enjoyable. I'm going to present a few introductory remarks about arbitration and virtual hearings, and the way arbitration is uniquely positioned to handle disputes virtually if need be, and also cross-border. So arbitration has always been noted for its procedural flexibility in terms of conducting meetings, and COVID-19 has only highlighted this advantage. There are two types of meetings that arbitration that take place in an arbitration proceeding and that can take place virtually. One is the procedural meeting, which is when parties are discussing with the tribunal the day-to-day proceedings, the day-to-day calendaring of the proceedings. And this was a norm before COVID-19 struck. And that arbitration has always been noted for this advantage because instead of having to go to a court, you could always arrange a telephone or a video conference to take care of procedural matters. The other aspect of the proceedings in arbitration were virtual hearings and virtual meetings are used is in the hearing phase of an arbitration. And for those of you who may not be familiar with how arbitrations work, they're like court proceedings, but arbitrations are a mix of different cultures, different legal cultures, the highlight of most arbitrations is a hearing which mixes features of both common law and civil law jurisdictions. So a tribunal, in order to decide a dispute, will hear the lawyers presenting and arguing their case, but the tribunal, as it does in common law jurisdictions like the United States and England and Wales, will hear witnesses to test whether the witnesses' recollections of events or documents is accurate or not. So, but the type of procedure that you have in arbitration is decided by the parties. And it's becoming more and more common for these hearings in which the tribunal really gets to see the dispute and to meet the participants in the dispute and to really judge the merits of both parties face to face. It's becoming more common for these hearings to take place over video conference, especially since there have been so many travel restrictions. And this is an advantage that arbitration has really benefited from, that you see more of than in the courts. In 2015, for instance, in one of the leading books on international arbitration, it's been said that in most cases, arbitration hearings may be held at any location convenient. It's only subject to any mandatory provisions of the seat of the arbitration. But it's generally there's no requirement that an arbitration be physically conducted in the seat where the arbitration is located.
Chris, I think that is a very important point, and that some people, especially if they have not experienced arbitration by themselves, do not understand automatically. Because if you think about the tribunal, of course, the seat of the tribunal will always be the place where you actually have the hearing. But we have to distinguish the place of arbitration and the place where the hearing takes place.
Yes,
Do I understand that correctly?
That's absolutely right, Martin. So look, when the parties in a contract, for instance, they want to have their dispute decided by an arbitral tribunal rather than a court, they'll say, we want to have binding arbitration in Paris, for instance. But when the parties say this, legally, that doesn't mean that physically the proceedings take place in Paris. The hearings could take place anywhere in the world. It could be Vienna or Beijing, or for the purposes of our discussion, it could take place both in Paris and Beijing at the same time as we're having this meeting today. That's to say virtually. So that the seat or the place of arbitration in a contract is a legal fiction. It's the legal place whose countries govern the arbitration, but it's not necessarily the place where the actual physical meetings take place.
And so that also means that I could choose an institution like CIETAC, although they are here in Europe, have their offices in Vienna, for an arbitration where I decide that the place of arbitration is in Paris, for example.
Yes, if you want to have an arbitration in Paris or in Beijing, which would mean that the laws, the procedural laws pertaining to international arbitrations in Beijing or Paris would govern those proceedings, not the court proceedings, but just certain mandatory provisions of law would govern those proceedings. But just because you say that the legal place of the arbitration is Paris, it means it could take place anywhere in the world.
And I can choose whatever institution I want to. So if I like CIETAC arbitration, although they are in Vienna, I can choose them for a dispute with a French company where the French company says, well, I would like to have the place of arbitration in Paris. Nevertheless, I can say, well, but I suggest CIETAC because I consider them most appropriate for a Chinese-French dispute.
That's right. And in fact, during contractual negotiations, and you know, I've been a negotiator in these instances, whether it's a merger or acquisition or another a type of contract negotiation. Oftentimes, the parties will compromise. So they'll say that, all right, we're going to have arbitration in Vienna, but it's going to be subject to the rules of arbitration of CIETAC, for instance. So you could have, you know, a Chinese-based institution like CIETAC, and now CIETAC also has offices in Vienna, and you could have the arbitration in Paris or Vienna at the same time.
Okay, thank you for the clarification.
And that's, you know, that's consistent with most laws of most countries in the world. For instance, in France, where the International Arbitration Act says, you know, unless the arbitration agreement says otherwise, it's the arbitral tribunal that shall define the procedure as required. So what that means is that the tribunal can say, all right, because this relates to, for instance, a construction project in Togo, in Africa, we're going to have the hearings located in Africa so that the witnesses, we can bring the witnesses together, and that you know, physically the proceedings will take place in Africa, but it could still be seated in Paris legally and governed by the French Arbitration Act. The only caveat to that is that the French Arbitration Act says the parties should be treated equally and that due process should be upheld. So, you know, if a place of physical hearing is going to be disadvantageous for one party, or for instance, if a virtual hearing might disadvantage one party in favor of another, then the French arbitration law would not allow that. So you know, you can, the whole idea is freedom, but it has to be freedom where both of the parties are on an equal playing field.
Sure. I think we're going to come to that also in our second panel, where we discuss more the problems that can arise. But it's an interesting point to note first that you start from the principle of freedom. You can decide how you want to put the different modules together. Arbitration is about the parties' autonomy to decide where they want to play their dispute.
Yes. And you know, the CIETAC rules, and you know, we're here with the representative of CIETAC. The CIETAC rules are perfectly in harmony with the French Arbitration Act and the arbitration acts of most countries in the world. For instance, under the CIETAC rules, the tribunal can hear the case in any way it deems appropriate. Although the CIETAC rules say the tribunal has to act impartially, fairly, and provide a reasonable opportunity to both parties. So that echoes, you know, what the French Arbitration Act says, that, hey, the tribunal can order any type of proceedings it wants, including virtual hearings, but whatever it does, it has to be impartial and fair. Because of COVID-19, we've seen an increase in the interest there's been a debate about, well, do you need to have a physical hearing? And the International Council for Commercial Arbitration, which is an international organization dedicated to promoting arbitration, for instance, has a research project out now that says, does a right to a physical hearing exist in international arbitration? And for me personally, I think the short answer is that if the right exists, and I'm not quite sure that that right exists, it can for sure be waived. And that's the case in most countries in the world. Because for reasons of economy, and I, you know, at the beginning I said hearings are a feature of international arbitration, that's for sure. But oftentimes in smaller cases where the amount of money doesn't justify holding a hearing, the case can be decided on documents only. And you see that in the arbitration rules of many institutions, like CIETAC, for instance, which says that the tribunal normally should hold oral hearings, but the tribunal may examine the case on the basis of documents only. And we'll hear from Mr. Sui Yang shortly as to what the practice of CIETAC might be. But when one looks at the CIETAC rules, which the parties can also choose in their contracts and in their arbitration clauses, you could say, I want arbitration under CIETAC rules with arbitration seated in Paris. Then it's good to know that in cases where a hearing is not necessary, the parties do have the freedom to choose an arbitration procedure without a hearing at all. And from my way of reasoning, if parties can have an arbitration without a hearing at all, then there should be no reason why they can't have a virtual hearing. Before I conclude, and I know my time is limited, I'd like to point out that the fact is that virtual hearings, many are taking place right now, and that it's inevitable that challenges will occur because lawyers being lawyers will always challenge, will always use any procedural excuse to use as a weapon in a legal battle. So one of the more publicized challenges, for instance, has been by the Kingdom of Spain in an investor-state dispute. And I have it here in the slide. It's Baden-Württemberg and others versus Kingdom of Spain. Basically what happened was the tribunal, because of COVID-19, the tribunals, two of the members came from countries that couldn't travel to the Hague where the hearing was taking place. And so apparently, according to the Global Arbitration Review, and the actual written arguments are not publicly available, but according to the Global Arbitration Review, what Spain did was they said, no, just because there's a 14-day quarantine doesn't mean that you have to have a virtual hearing. And from what I understand, Spain had tried to challenge this tribunal on other grounds. They had failed, and they're now using COVID-19 as an excuse and saying, well, the tribunal is definitely biased against Spain because they are denying Spain the right to a physical hearing. The reasons why the arbitrators said they couldn't come to The Hague are fake reasons, and that's why we're challenging Spain. Now, I don't know all the facts of this case, and it may be that Spain does have some justified concerns as to bias, and I don't know exactly how the tribunal explained itself, but from an outside point of view, it seems quite reasonable to have a virtual hearing, as long as that hearing gives a full, fair, and equal opportunity to everybody. But that's, that not being a fully public proceeding, I can't comment any further on it. Some closing thoughts. You'll see a lot of articles and commentary on what are called mixed hearings. Sometimes they'll call it hybrid hearings, not to be confused with hybrid ADR procedures, which is different. That's using arbitration and mediation together, or other types of dispute resolution mechanisms. But hybrid hearings in the context of virtual hearing means where some people in the hearing, for instance, some members of the tribunal might be with one party together, physically together in a room, and another party and the other tribunal member might be participating virtually. And then witnesses might be separate and all the parties might be together, or any combination of people being physically together and some other people being in a virtual environment. So that raises a lot of questions. What does due process demand? Do representatives from both parties have to be physically present with a witness to make sure that they're not being coached? I've been in a hearing before COVID in which one party did insist on having its representative in South Africa, even though the hearing was taking place in Paris, so that the witness was accompanied by representatives of both parties. or does a witness have to be give the testimony with nobody present if they're doing it virtually? And then how do you be sure in a virtual environment whether there's whether people who are not authorized to be in the hearing are there, maybe giving advice, or simply breaching the confidentiality of the proceedings? Guides to best practice are starting to be published. Webinars like this you see them more and more often, and I think it's a good discussion because clearly virtual hearings can save money as opposed to physical hearings, but you know, there's a cost to that, and you know, is that cost worth it? So I thank you for this allowing me to give a brief introduction to arbitration and virtual hearings, and I look forward to hearing the comments of the other panelists. Thank you.
Thank you very much, Chris. I forgot to tell the audience that Zoom provides for a wonderful tool. If you want, you can use the questions and answers section, which you just find below, and you could put in your question, and we will deal with that question during our conversation or in the 10 to 15 minutes after the end of the 3 presentations. So please do not hesitate to bring up your questions because for us it's always interesting to see where the public stands, which parts are maybe a little bit too complicated. We know there are lots of different terms. There are terms also, like Chris just said, hybrid arbitration that are used in different ways, which can make it more confusing for people who are not as familiar with arbitrations as our learned panelists today. But now I have the chance to give the floor to my learned colleague and the assistant secretary of CIETAC in Europe, Mr. Tzu Yang, and I would like to give you the floor to be able to present your words and your ideas and those of CIETAC on the issues of virtual hearings.
Thank you. Good morning. I'm delighted to share with you some of the CIETAC's responses to COVID-19, especially CIETAC's online hearing platform. The COVID-19 brought new issues that affect the administration of arbitral proceedings. CIETAC, as many other arbitration institutions, faces the challenge to ensure the fairness and the efficiency of arbitration and to protect the health and safety of arbitration participants at the same time. CIETAC took 2 major measures in April. The first was the publish of guidelines on proceeding with arbitration actively and properly during the COVID-19 pandemic. And the second was the launch of its online hearing platform. The guidelines suggest that the participants take full advantage of digital technology and the current tools in the arbitration rules, such as online case filing, electronic service of documents, virtual hearings, etc., to mitigate the effects of the pandemic and proceed with the arbitration proceedings. Since the launch of CIETAC online hearing platform, 165 cases have been heard virtually, with parties participating from 30 different cities from the US, Canada, Australia, Sweden, Hong Kong, and mainland China. And as Chris mentioned, where the document-based arbitration will be a new trend, where we have seen over a dozen of cases were examined on a document-based, on a document-only base this year. In virtue of its online case filing system launched in 2019, CIETAC is able to encourage parties to take full advantage of this system to file their arbitration application online as early as January, when the pandemic just broke out. This year, over 400 cases have been filed online, which is more than a total number last year. The system solves the problems in non-contact case filing with the functions of consultation, identity verification, and online submission of arbitration application documents. The scanned copies of business license, personal ID, and the power of attorney can be uploaded to the online case filing system for identity verification. After uploading the application for arbitration and its attachments, the claimant would receive feedbacks from the message box. The system will also push notifications of new messages on WeChat, which is the like the WhatsApp in China, to the claimant if the CIETAC service account on WeChat is followed. The claimant can also leave messages to us on the system for following queries. In fact, CIETAC published its first online arbitration rules and launched an online arbitration system in 2009. But it was not so popular before COVID-19 outbreak. Just a very few cases were administrated and examined on that system in the last 10 years. After the pandemic, CIETAC built up a new online hearing platform and released its guidelines on virtual hearings based on CIETAC arbitration rules. Evidence such as audio, video materials, and electronic data could be easily presented on the platform. Compared with free public platforms, customized video conferencing platforms are better in terms of security, confidentiality, and data protection. With such technology and procedural regulations, the participants can join a virtual hearing from any place, preventing the risk of in-person gathering during the pandemic, cutting the time and the cost for the parties, and carrying the procedures forward. The guidelines make it clear that the virtual hearing is a specific method of oral hearing, which is in accordance with Article 25 of CIETAC arbitration rules. During the pandemic, for cases to be examined with oral hearings, the arbitral tribunal is advised to first consider the possibility of holding virtual hearings. The guidelines also provide that when deciding whether to hold a virtual hearing, the tribunal shall take into comprehensive consideration a variety of factors such as parties' opinions, the complexity of the case, any witness to be present, the justification of parties' reasons against holding a virtual hearing, and the convenience and equality of the participants to access to the virtual hearing facilities. Where a virtual hearing is conducted, the tribunal shall fully protect the procedural rights of parties, afford a reasonable opportunity to both parties to present their case, and treat both parties equally. After consulting with the parties, the tribunal may adopt one of the following means of virtual hearings based on the specific circumstances of the case. First is where the arbitrators, the parties, and other participants are located in different parts of mainland China. It's encouraged to hold a virtual hearing via CIETAC online hearing platform. Where the arbitrators, the parties, and other participants are located in different jurisdictions, if it's more preferred, a virtual hearing may be conducted via other video conferencing platforms agreed by the parties and approved by CIETAC. The reason for CIETAC's approval is to make sure that the chosen platform has access in mainland China, so our case manager can join the virtual hearing.
So once again, if I may step in, once again, that's an example that arbitration is completely flexible as long as it works for the parties. And of course, that there's some sort of overview by the institution, by CIETAC. The parties are completely free to even choose the online conferencing platform.
Yes,
so,
our online hearing platform is not mandatory. It's just providing an option to the parties and online platform operated by a third party to mitigate the risk of technology failure used against the another party. But if both parties agree to choose like Zoom, totally fine.
And your platform, do you charge extra fees for that, or is this included?
No. We don't charge extra fees.
Well, who can refuse free lunch?
And for the surface of documents, the parties are encouraged to submit and receive arbitration documents via emails and the online hearing platform. If the party choose CIETAC online hearing platform, the case manager will send a unique code to the parties and other participants. They need to enter the received code to log in the hearing room of the case. To mitigate the risks of accidental leak of the code and unauthorized attendees, the online hearing system has the facial recognition function, which linked with the police database. But this function is only available for Chinese participants who have Chinese ID cards. For foreign participants, they will be asked to show their passport under camera. If the parties need to verify the originals of certain documentary evidence or physical evidence, they may do the verification at the nearby CIETAC branches. And especially in case with witness, having the witness to participate in the virtual hearings at the nearby CIETAC branch under the supervision of CIETAC staff members could also ensure the independent presentation of the witness. For example, in this June, an arbitration case accepted by CIETAC Hong Kong was held simultaneously in 4 cities of 2 countries. CIETAC Hong Kong held an oral hearing of virtual and in-person combination with the aid of CIETAC Fujian subcommission. The witness of the claimant attended an oral hearing in Xiamen City, where the CIETAC Fujian subcommission locates. The witness of the respondent participated in the hearing online in Melbourne under the supervision of the claimant's representative. The stenographer participated in the hearing online in Shenzhen City. So by the witness and the assistance of CIETAC Hong Kong and CIETAC Fujian ensured the smooth operation of the hearing. CIETAC now has 15 branches located in mainland China and overseas, and has concluded cooperation agreements with over 70 dispute resolution institutions across the world, with arrangement to mutually provide hearing facilities and assistance. This has made it possible for CIETAC to satisfy the need for a hearing mode of virtual and in-person combination in some special cases. And it also helps to relieve the concerns on the risk of unfair procedures in some circumstances, such as the instability of communication equipment and the network used by some participants, and if there is an unauthorized person hiding behind the screen.
So I think even in, or also already in Paris, you have a cooperation partner, so that parties can go to their offices and do not have to be afraid that they have to set up a very complicated tax system just for the purposes of this hearing.
That's right. Yeah. So CIETAC's approach to concerns on virtual hearing under Chinese law. I think perhaps the biggest concern on virtual hearings is in the case that when the claimant requests a virtual hearing while the respondent objects and prefers an in-person hearing. Can a tribunal hear the case virtually? And if the answer is yes, will the laws and regulations affect the enforcement of the award? Article 39 of Chinese arbitration law says an arbitration tribunal shall hold oral hearings to hear a case. The oral hearings in Article 39 should mean in-person hearings at the time when the law was drafted 26 years ago. So the question arises if a virtual hearing is a kind of oral hearings. And on February the 14th this year, the Supreme People's Court of China issued a notice of strengthening and regulating the online litigation work during the period of prevention and control of the COVID-19 outbreak. Its Article 2 reads, the People's Courts at all levels shall respect litigants' right to choose modes of handling cases. Where litigants disagree with online case handling and apply for trial postponement, according to the law, the People's Courts shall grant permission and shall not compulsorily apply online litigation. So our approach, the CIETAC guidelines make it clear that virtual hearing is considered as a specific way of oral hearing, and encourage the tribunal to first consider the possibility of holding virtual hearings. And in CIETAC practice, most of the tribunals will require the parties' consent on conducting online hearings. If one party objects to virtual hearing, it's more common to schedule a hearing with physical presence. It might bring longer waiting time for an in-person hearing, but it also reduces the risks related to enforcement or setting aside proceedings against the award. Thank you for your patience.
I think that last point is a very, very important one, because of course nobody wants, especially as claimant, have an award that finally will be set aside, because then all the work and the costs that you invested are completely useless. So I can understand that you have a very prudent approach in the beginning and say, okay, of course we favor consent to avoid that. But maybe we will see also some standards developing where courts will later say, okay, under some reasonable circumstances, even if there's one party that just objects, because as a defendant, you might have a strategy to say, I want to delay any arbitration as long as possible to avoid an award to be given at all, to set up some standards to say, even in the case when one of the parties objects, if that objection is not justified by any special reasons, then the arbitral tribunal should still be able to go to virtual hearings. But this is, we will talk about that in our second panel, and I think that will be evolving in the next years. But it's interesting already that you have a very friendly approach, and also the Chinese People Court, to say, well, oral hearing can also mean virtual hearing. It's not something completely new. It's just that you're a little bit further away than you would be if you're just sitting on the other side of the table.
Mm.
Okay, that brings us to our third panelist, Ann-Karin Grill. And I would like to give her directly the floor, so we might have, after her presentation, even some time for questions and answers from the public.
Sure. Thank you to the organizers of this event. It's a great pleasure for me to be addressing you within the framework of China Arbitration Week 2020. I also thank our colleague, Mr. Su Yang of CIETAC's Vienna office to host us for this meeting. And I was following his comments very attentively, because for me the question is always, how can we make best use of what the institutions provide for us in terms of a framework to assist the parties in settling their disputes? And what I have prepared for you today is a little overview of how we do it in Europe and how that could possibly also work in a China context. So I'll take you through my slides, and I will be happy to answer any questions that you have. So to get us started, I want to address the European landscape just very briefly. And I do this to make everybody aware that also in Europe, and especially in the jurisdictions that I am most familiar with, and this is actually Austria and France, we know how to address dispute resolution, and we have a full toolbox available to deal with disputes, commercial disputes. And we are looking at traditional mechanisms such as court litigation, and then we look at alternative mechanisms, and that's arbitration and, to an increasing degree, also mediation. And when we look at those alternative or amicable dispute resolution techniques, we see also an increase in the different nuances that we have in that field. And we turn to pre-dispute ADR to assist parties to manage their projects in a way that no disputes arise at all. And if that happens, we look at post-dispute ADR, such as conciliation or mediation, to quickly deal with the resolution of the dispute. And then also in Europe, we have a concept that is called collaborative law. And that means you bring in a specialized lawyer who is trained in alternative dispute resolution methods to negotiate a solution. And only if that does not work out, the lawyer leaves, you hire a new team, and then you go and have the confrontational litigation or arbitration. So this is just to set the scene and to make you aware that in Europe, people are also increasingly sophisticated when it comes to picking the right method of dispute resolution. I also want to share with you the frameworks and concepts that we work with here in Europe. And basically, I have here 4 bullet points that really address the main issues, the questions that we need to answer when we go and try to resolve a dispute. So we need to decide, are we going to do this in an institutional framework, such as the one provided by CIETAC or other institutions worldwide, or are we going to arrange everything privately and do it on what we call an ad hoc basis, which is clearly more work for the lawyers because you need to agree on all the steps in the procedure. Also, if you have already decided that you want to try a less confrontational and more amicable dispute resolution method, you need to be clear what it is that you are asking from your neutral that is coming to the table. Are we looking for a mediation or conciliation? And in Europe, the big difference between the two is that the mediator does not make a proposal as to what the settlement could be, whereas the conciliator is very active in working with the parties and proactively proposing solutions. So this is a very important distinction that we need to make before we decide on what it is that we want to do. Chris has also already mentioned that there is this concept of hybrid proceedings, and it is indeed increasingly something that we see happen in commercial dispute resolution in Europe. So this is what we refer to in technical terms as med-arb, so a combination of mediation and arbitration, or an arb-med, where we start with the more confrontational and then realize that we want to negotiate rather than ask a tribunal to reach a decision. And the most common commercial hybrid solution that we see in Europe is the arb-med-arb proceeding, where in the procedural framework of the arbitration, the the parties agree to have a mediation window, a phase that is dedicated to seeking a negotiated solution. That
I have and Karin, if I may step in, I have a question from the public, because there seems to be some confusion about what hybrid means. Because there are some people who also talk about hybrid hearings and hybrid mediation. So when we talk about hybrid proceedings here, we are saying it's a changing of phases of mediation and arbitration. That has, first of all, nothing to do with remote arbitration, virtual hearings whatsoever.
Yes,
correct.
This is absolutely correct. And I am aware that this denomination is probably causing confusion, but the term hybrid just serves to express that we are combining different methods. And in this case, in the ADR proceedings, we are combining arbitration, which is more confrontational, with mediation or negotiation, which is more consensual. And in that context, I believe one of the most burning questions that come up when we compare the classical European frameworks and Asian Chinese frameworks is what the role of the neutral is. And in particular, can an arbitrator also serve as a mediator in the same proceeding? And the understanding here in Europe is very strict, that you need to separate the two roles, whereas in China and Asia, the parties and legal professionals are more flexible. And we actually see that reflected in Article 47, of the CIETAC rules. And I have highlighted the relevant passages of the provision for you. So basically here very clearly we see that if the parties consent, the tribunal, the arbitrators, may also serve as conciliators. And if the conciliation is not successful, the arbitral tribunal resumes the arbitral proceedings and will render an award. And what is very interesting to see, at least from a European perspective, is that Article 47 also addresses the other situation, which could be that the parties do not agree that the tribunal assumes also the role of a conciliator or a mediator, or intervenes with proposals in the negotiation. And in that contingency, the CIETAC will intervene, and with the consent of the parties again, assist in finding a third party to conduct the conciliation with them. So this is really one of the main differences in approaches that we are able to identify when we compare European style ADR with Asian style ADR. And that takes me to my next slide, which is addressing a little reality check. So basically we know the concepts and the theories and the framework, but what does it look like in real life? And I'm speaking here from my experience as both a counsel in arbitration, an arbitrator, and a mediator on international cases. So what I observe in my practice is that we see hybrid proceedings, we see a combination of confrontational and consensual dispute resolution methods, rather in an institutional context. So essentially, dispute resolution service providers like CIETAC stepping in and assisting the parties in administering their cases. And the reason for that is that the procedural rules of the institutions provide for flexibility in the sense that the parties can switch between the methods without additional cost, without losing time, and with the support of institutions that can be very helpful in advising on how to proceed. Another thing that we see in reality is that while there is amongst certain members of the community a degree of flexibility when it comes to this issue of the arbitrator also taking the role of the mediator, in practice, in Europe, the two roles are very separate. So we'll never find an arbitrator also acting as a mediator. What we also see, and this goes back to the preference for institutional frameworks, is that the parties are keen to have the option of a tribunal issuing a consent award. So that means if you are in an arbitration, you switch to mediating or conciliating the case, and you find a solution, then the parties want the option of going back to the arbitral procedure to have the settlement recorded in the form of a consent award. And the reason for that is that the parties don't trust the goodwill of the other party to actually comply with the settlement. So they want to have a secure option of enforcement. And in arbitration, as we all are aware, we can easily resort to the instrument of the New York Convention, which means that we can enforce our awards literally around the globe. And
so finally, that means a consent award has, from the outside perspective, exactly the same value as a dispute award.
Yes, correct. So basically, if you are able to combine methods in a smart way, then you can have really the best of both worlds. You can have a solution that was driven by the parties, and you have the safety net of enforcement if something goes wrong in the compliance phase. So with that, I want to come to the last point of my reality check slide, and that is a clear message. It's been tested over the past months, and virtual mediations, virtual ADR solutions work. And when I say that, it's not only from the perspective of a practitioner, of a mediator, because for us, of course, having virtual meetings is just a little bit more work than being able to meet the parties in person, because you need to master the technology, you need to be comfortable with you know, the handling and managing the process through your computer and not on a sheet of paper when you're taking notes. And you need to work harder to connect with the people. Because for me, I'm not even aware of the number of people who are listening to me right now. I just see 4 faces on my screen. So I need to have, you know, this mindset of me speaking with, you know, somebody that's not across from me, and really get across my points and keep up the energy. Because when you're working on a screen, you don't get the benefit of sensing what is going on in the room. So you need to be very engaged as a professional, but on the other hand, you need to rely on the dedication of the parties to make it work. And what has proven very effective is the use of split meeting rooms. So where you actually split up the parties in separate virtual meeting rooms, and then you as the neutral, as the mediator, you shuttle between the 2 meetings. So shuttle mediation, I think, is really the key to making best use of virtual tools. And just to come back, yes?
Yeah, because that was a question from the public where they said, well, mediation normally needs that the mediator talks to one of the parties in private and then goes back to the other party and tries to bring them a little bit closer, or at least make them aware of the position of the other party, which is quite complicated. And so you would say that can also work if it's only a virtual hearing. Technology is so up to date that it provides the tools for doing so.
Yes, absolutely. So I just successfully worked through a problem in a shareholder dispute in the pharma industry segment. And we had shareholders from Ireland, Germany, and Austria participating in the mediation. And basically my job was to work with the parties separately. We started out in a joint meeting room. We set the stage, we defined the issues together, but then we split up and I worked with one party, then I brought the other party on board, and it was me really just shuttling between the parties. And the more you engage in private meetings, the more you understand what is behind the requests of the parties, and that gives you the opportunity to really convey the message and to bring about a good deal. So actually, and this is coming from somebody who has experience in a few mediations already, working through virtual means can actually be an advantage because you gain time. You gain time to think about your position. You gain time to think about the words you choose to present your requests, and you give time to your mediator to really think of how to drive the process forward and to highlight the benefits of a negotiated solution. So I am very happy to be a testimonial for the use of new technology in dispute resolution techniques in times of COVID-19. And it does not mean that we all won't be happy to go back to personal meetings, because overall they are preferable. But we now have the tools available that allow us to really work across borders, across time zones, and despite public health challenges, with ease and with success. And
thank you. But
yes?
Sorry, Ann-Karin, but we are running out a little bit of time, and I still have lots of questions from the public.
Sure,
but
sure.
We will only take one, which I think is a very interesting one. It's for Mr. Tsui Yang, and it's a question about translation. How can translation work in a virtual hearing? Because that is, especially when it comes, when I think about Chinese, French, arbitration, I've seen contracts where the party said everyone can file their submissions in his own language and can also present at the hearing in his own language, which means that we need translators from Mandarin to French and vice versa. Do you already had these cases? Do you have a technical solution for that, so that, like the stenographer, which who is in another office apart from the parties, a translator could also listen directly to the stream of sound from one of the parties and translate it for the arbitral tribunal, which might need even another language if the arbitration is in English, to make it technically work? Because I could understand that this is much harder for the translator and for everyone in a virtual environment than if everyone is in the same room. Oh, I just have to activate your micro. 1 second. Yes, now we can hear it.
Yes, that's true. Exactly like what you have said. But in reality, as far as I know, we haven't met any technical problems with this interpretation or translation. The interpreter can smoothly translate for different languages. We have this channel for the interpreter. And as far as by now, everything goes quite well, quite well.
Okay, perfect. One headache less to think about. And there was one last question for Mr. Chinn. People were asking what sort of button you are wearing there. And I'm also curious about this. Is that some sort of knight awarded by the Queen?
Sort of, yeah. This is the Chartered Institute of Arbitrators pin, and I'm a fellow of the institution, and so is Anne-Karin. And what we do is we promote ADR around the world, and we act as arbitrators and as counsel, and we participate in webinars just like this one. So
okay.
And this is the insignia. The Chartered Institute operates under a royal charter from the Queen, and this is the heraldic symbol of our order.
So even the Queen is promoting arbitration and alternative.
Even the Queen promotes arbitration.
That's a good sign for peace in the world. Okay, thank you very much for your presentations in this first panel. We are nearly exactly on time for our second panel. So thank you very much, Anne-Karin, and thank you, Christopher. We will certainly see you again in another webinar because there's so many issues we were just able to touch a little bit, and which will be evolving in the next months and years. So I hope we see you again for another webinar. Thank you very much. Mr. So Young will stay with us to be able to have somebody from the CIETAC to maybe ask questions or enter them in our second panel, because I think that will also be a very interesting discussions now about what legal issues arise from the use of virtual hearings. Thank you very much. So now I call to the floor Mr. David Capitan. Technically that should work because Zoom provides us with tools that really resemble what you can do in physical meeting. And now he is up, perfect. Mr. David Capitan, he's a professor at Sorbonne University. He speaks more languages than I can remember, but just to mention a few: English, French, German, and Spanish, and Italian are among these languages. He has experience as expert in arbitration and also, of course, as a professor talking about this subject. He's also an off-counsel, so if you need a lawyer, don't hesitate to call him too. Our second panelist is Ms. Ho Wai-Sun. I will try to call her up as well, and magically it works. She joins us from Beijing and is a lawyer and arbitrator at Junglin law firm. And I think we have met in Vienna previously. She will tell us in the beginning of her presentation a little bit more about her work. And I would like to call our third panelist. His name is Georges Arama. He's from KJ law firm. He's the partner heading the arbitration department of KJA. And for more than 30 years, he has been involved in arbitration and negotiations in Africa, especially for large investments, for any sort of structural investments, especially also from Chinese companies. Just to mention the last two negotiations he had with China Railway Construction Corporation and China Railway Vehicles Corporation. So Chinese parties are familiar with ADR in Africa, although, since we learned from Chris, the place of arbitration can still be in Paris. You can choose Paris as place of arbitration, and for example, CIETAC as your institution, and have the hearings held in Africa if you think that it's appropriate, because there are some of the evidence or some of the infrastructure projects that you invested in locally in Africa. Or you can, of course, also hold virtual meetings, especially in times of COVID when traveling becomes or stays difficult. That can be a solution. And I would like to start directly with my learned colleague, David Capital, and his presentation, who will hopefully give us some ideas how we can counter some of the legal obstacles that we have already heard of, and the risks that parties encounter when they choose virtual hearings. As with any technology, everything that is new is the risk of being subject to case law. And case law means it's great for us lawyers because we see interesting cases coming up, but it can be a little bit more difficulties for the parties, because it means an award that has been pronounced might be a risk later on. So we will have first from David his opinion on the current situation. Thank you. David, I cannot hear you. Did you turn on your microphone?
Is it working now?
Yes, perfectly.
Okay, and can you see my PowerPoint? Because I cannot see it myself.
I can see it.
Okay.
It looks perfect.
So I'm speaking about remote hearings and COVID-19 crisis. Remote hearings are nothing new indeed, but the COVID-19 crisis have made the issue more topical than ever. Most steps in an international arbitration are already done remotely nowadays, especially holding case management conferences that are often organized as telephone or video conferences, exchanging written submissions via document share platforms, or even it is not uncommon that certain witnesses or experts testify remotely. But hearings, either on the merits or on major procedural issues, remain mostly physical meetings. In time of COVID, the question is, should physical hearings that cannot be held due to travel restrictions be postponed or be held remotely? And this makes the point more actual than ever. What I would like to address is what is the risk of potential challenges to awards based on remote hearings, and particularly with regards to the right to be heard and to the right to be treated equally. Different types of remote hearings may be distinguished, first of all. On the one hand, semi-remote hearings use one main venue. For instance, the tribunal might be assembled with the parties in one location, and one or several witnesses or experts might testify before them remotely. Such a setup is regularly practiced in international arbitration. On the other hand, in fully remote hearings, all participants are in different locations with no existing main hearing venue. Fully remote hearings are rarely used in international arbitration so far, but are currently considered in many proceedings in order to deal with COVID-19 related restrictions. Moreover, remote hearings might be distinguished according to the content of the remote part, as remote legal arguments might be assessed differently than remote evidence taking. Finally, semi-remote hearings might raise different questions depending on which participants are remote. While the hearing of remote witnesses or experts is most common, there are instances where one or both of the parties participate remotely, or one or both co-arbitrators. All these elements of complexity must be taken into account. The first point, I would like to address the regulatory framework of remote hearings. The assessment whether or not remote hearings are possible depends on the applicable regulatory framework, and in particular, the law of the seat of the arbitration and the chosen arbitration rules. Most national laws and arbitration rules do not contain any specific provisions on remote hearings. A number of arbitration rules contain references to remote hearings, but only in particular circumstances. For example, Article 28 of the Unilateral Arbitration Rules provide that witnesses and experts may be heard remotely, but it contains no similar provision for other aspects of hearings, such as legal arguments. According to a contrario reasoning, does it mean that because remote hearings are expressly permitted in certain circumstances, they are impliedly prohibited in all others? But it is difficult to conceive why legal arguments could not be heard remotely if remote testimony by witnesses or experts is allowed. In the absence of a text, it is necessary to resort to general principles of arbitration and above all, the right to a hearing. It is established that the party had the right to a hearing. The question remains whether this necessarily means a physical hearing. Certainly, hearings must be oral. This is a principle of orality. And hearings must allow for a simultaneous exchange of arguments or evidence. This is the principle of immediacy. In essence, we can say that a hearing consists of an oral and synchronous exchange of arguments or evidence, as opposed to the written and asynchronous exchange of arguments or evidence in the parties' briefs. As long as a remote hearing allows for the exchange to be oral or synchronous, it seems difficult to argue that it's not a hearing. This leaves, however, the question open as to whether or not arbitration tribunals may resort to remote hearings if the national laws or institutional arbitration rules contain no specific provision on remote hearings. And to that point, we must take
just David, if I may interrupt you here, because I think that is an important point, which for some people might be not so clear, that you emphasize that it has to be synchronized. So at the same time, everybody has to see the same picture and hear the same sound. And there, I think the technological solution comes in to avoid that you have a sort of maybe delay, technical delay, where one of the parties, because they are in a different country, might get a delayed signal and every time have it more difficult to step in or react what the other party says, just because there's a lack of maybe, or in the worst case, several seconds, maybe even a minute. So the concentration on a good technical solution can already solve a legal problem finally.
Yes, I think it's the technical issue is very important as for remote hearing. The two rights that are quite problematic, on the one hand, the right to be heard, and on the second hand, the right to be treated equally. As for the right to be heard, finally, if we assume that a remote hearing is quite equal to a physical hearing, as it allows to make a cross-examination, it means that both parties can ask the question to the witnesses and experts. Of course, there is no problem of principle. The problem that could arise is more technical. if there is a technical issue during a cross-examination, then one of the party could pretend and then challenge the award at the end of the arbitration process, saying that it has not had the possibility to make the cross-examination like the other party. And therefore, this is very important to take all the prevention in order to have a good and efficient technological organization. And
so Yang, could you tell us if CIETAC has experienced cross-examinations through virtual hearings, and especially on your new virtual hearing platform? How does it work good in practice, or is it something where you say, well, when it comes to cross-examination, people have to be very prudent, very careful, because that is something, a very stressful situation for everyone. So it demands even more cooperation between the parties to make it happen.
Well, you know, because I'm here in Vienna, so I haven't handled any cases anymore. So I heard from my colleagues in CIETAC Hong Kong Center, as I introduced in my presentation. In their case, the cross-examination went quite smooth, it's quite well. But I just heard from my colleagues, and maybe they didn't tell me the whole picture, so maybe some details or information I missed here.
Okay, but it's in general, it's possible. So, but it's an important point, David, that you raised, that at such an issue as cross-examination, we have technical problems, then this could be a nightmare for any annulment proceedings afterwards, right?
Yeah, that's completely right. And that should be addressed already at the beginning of the process. And you should have a nice provision in the arbitration clauses in order to know what happens when such a technical issue arises and who is responsible for that and how you can manage that. Another point that could be also problematic is that if you want to have if you use the right to be treated equally, and the problem could be also the possibility for one party to influence an expert or a witness which is heard remote. If the witness or the expert is in the main venue, the tribunal can see what happens, and that the expert is not speaking to anybody at the moment of the cross-examination. But if you are remote, if the expert of the witness is remote, then you can suppose that maybe there is somebody influencing him or training him or trying to influence him. And so
as you talk about expert witness, and I know that you also see it from your own professional perspective, maybe although George is presenting later, but this question I would like to pass on to him, because we know that especially in construction, arbitration, we often see that there's the use of so-called hot tubbing of experts. Those who are not familiar with the term, it just means that you put one expert next to the other, normally experts of the parties, and you ask them the same question to be able to understand where they finally agree upon and what questions they disagree. Because for a non-expert such as the arbitrator, it is often quite confusing when you listen to one expert first and the other one after him, because you have the impression that although you ask the same questions, you are looking at two different sides of the same matter. So in international arbitration, one of the tools that is generally used is hot tubbing. You put them together in the same water, so to say, and try to find out if they agree and on what they agree. Because if these points they agree upon are the most important ones for the arbitral tribunal, well, then the problem is solved and you don't have to become an expert on your own as an arbitrator to go further into it. George, from your experience, would you think that hot tubbing could be used in virtual hearings, or would you say that is so, because we're even one step ahead of just cross-examination, would you say that is something you should be very careful to try in a virtual hearing?
Thank you, Martin. Can you hear me?
Yeah, perfectly.
I think the question of the hot tubing is very important because, as Anne-Karin said, you have to feel something during the hearing. So when you have a hot tubing and both experts with the same question, the tribunal is just in front of them. And it's very important for the arbitrators to see what each expert is going to say or will say. So for sure we can try. I didn't try yet the hot tubing, virtual hot tubing, but I don't see any major problem to have a virtual hot tubing. But we have to be sure that both experts will be exactly on the same situation and with an equal treatment, and to be sure that every expert will be able to raise his point of view and to explain his point of view, and to be sure that the tribunal, the arbitrators, will be able to ask them more questions during this very, very precise kind of procedure.
So people have to be probably even more polite than they should be in a normal arbitration, because if there's one expert who's very fast and might even have a technological advantage because he hears the question a second earlier than the other one, if he always goes first, then that might create a problem for the sort of hot tubbing. So I think the general rule of giving everyone the possibility to answer a question is also something that is important to observe in virtual hearings.
Yes, for sure, but I don't see any kind of problem in virtual hearing, and especially for this phase of hot tubing, because if the both experts are on the screen and if they can see the arbitrators, it is always the same rule. First of all, one expert is going to answer and the other one is going to make his point of view. And as you can be sure, both experts will not be exactly on the same loop. So it is always a problem of making things easier to be sure that the arbitrators will understand the point of view of each expert on a special point.
Okay, thank you, George. Sorry, David, that I interrupted your presentation, but I thought that was an interesting point, and it's interesting to see how people from the other side, like us lawyers, counsels, who have to ask the questions or make the arbitral tribunal ask the right questions to the experts, see that problem, but apparently it's less of a problem than I thought it would be. So David, what do you have as other issues where you would say, well, that could compromise finally the arbitral award?
I think that one very important thing also is to avoid as much as possible semi-remote procedures, because then you could have the problem of inequality treatment of both parties. And if one party is remote, it's better to organize the whole procedure with both parties remote than with one in the main venue and the other one away, because as you said, there are some technical issues that could arise and that could weaken the whole procedure at the end and make easier a possible challenge of the award. If you have one party and its experts and witnesses that are just in front of the tribunal, and another party, and this could happen in international arbitration when if you choose, for example, Paris, you have a French company being in Paris and a Chinese company being in China, and they cannot come all together because of the COVID-19. Then it's better to organize the whole procedure remote for everybody, even for those who are able to come to the tribunal, because so you avoid an unequal treatment, which is one of the main weakness of every remote procedure.
So you are, I understand that you are not at all in favor of semi-remote proceedings, meaning there's one party next to the tribunal and we just have one video conference with a party that cannot make it to the hearing place.
Exactly, but of course you have to distinguish between different types of semi-remote hearings, because it depends on who is remote. So if it's an expert that is cross questions by both parties from the same side and with the same means, then there is no problem with the right to be treated equally. On the other hand, if you have one party who make the examination from one side and the other one not, then you could have some problem, even if most of the problems may be solved with a good technical material on one hand and a good preparation. And this is something for the councils of the parties to be able to see and to prevent the occurrence of any problem, not only technical but also juridical.
So your recommendation would be, even for example, if the other party who is remote says, okay, to make it technically more easily, I accept that claimant is sitting next to the arbitral tribunal, you would recommend to the counsels for claimant to say, well, don't accept that gift, even it looks too sweet. If something is too good to be true, then it might just be not true, because it could cause lots of problems and headaches later on. So better stay with the solution where everyone is remote and everyone is facing the same situation.
Exactly, this is the point I would like to stress. Well, the last thing maybe I would like to address and to mention is the problem of the agreement of the parties. So it may happen that the parties are both against a remote procedure or both are okay. The problem arises when one party wants a remote part of the process to be held remote and the other one not. And then this is the question of the power of the tribunal to impose to one party a remote or semi-remote procedure. Of course, we can face different situations. Most of the laws that are applicable do not prevail anything, and so it's better to write in the contract at the beginning, in the arbitration clause, to speak about remote procedure, which most of the time is not the fact.
So I would like to have the arbitrator's perspective on that. And since I know that Huai's son is an experienced arbitrator, I would like to know from her if she also considers semi-remote arbitration hearings, which means that one of the parties is sitting next to the arbitrator and the other party, the opposing party, is only participating by video conference. Would you consider that as a problem, or is this something that, especially in China, is more and more familiar because people say, well, it's technically the easiest solution, so we go for it, and we don't see a problem as some people might see it in Europe?
Thank you, Mr. Liao. And it's indeed our concern as arbitrator. Actually, recently we have we are discussing how to conduct the virtual hearing, and it is a Hong Kong seated hearing, and the 3 arbitrators are located in 3 parts of the world. One is in Hong Kong, and one is me in Beijing, and another one is in Europe. For some parties, they raise the possibility that one of the arbitrators travel to the place where the witnesses are located, so that at least one arbitrator has the opportunity to observe what is happening with the witnesses. But as arbitrators, at the arbitration tribunal, we are indeed concerned about the equality for arms between the parties. We decided that we don't want to have this happening. We decided to hold the hearing entirely virtually. None of the arbitrators will be present with the parties. So it's although it's possible that one side of the council is at the same location with one arbitrator, but we decided that we will hold the hearings all virtually to make that everything is equal among the parties. So this is indeed one of the concerns.
So we have the same concerns, and even already the same solution for it, to say, well, the basic principle should always be equality. Everyone has to be treated the same. And even if the parties want to make it differently, it's better for the arbitrator to say, no, if one of the parties has to do a remote hearing, then it should be the case also for the other party, although the second party might be in the same city as the arbitrator.
Yeah. This is what I have experienced just now.
But that could bring us also to the interesting situation that you have one party who says, well, I could travel, but I consider, for example, Paris as a risky region for the coronavirus. So for health concern, I don't want to travel to Paris. And the other party says, well, I'm based in Paris. We agreed in the arbitration clause for place of arbitration and maybe even for the hearings to be held in Paris. I want a real physical meeting. So I refuse to go into my video room and participate only remotely, because what we agreed upon in the beginning was a physical hearing. So if one of the parties doesn't want to come, so fine, but that should not deprive me from my possibility to talk directly to the arbitrator. What would you say to such a party?
Yeah, I think that will require the consensus reached among the arbitrators, because ultimately it will be an arbitration tribunal who makes the decision. They can hear both parties' arguments and also to assess whether, for example, the other party who is strongly opposed to such a way of having one party being present with the tribunal. So I think each case will be different. Sometimes the parties are more concerned with the opportunity of appearing before the tribunal. And sometimes the parties can also accept the possibility that the hearing be conducted virtually.
So Young, in such a, of course, it's a fictional case that I'm making up. But what would be the position of CIETAC? Because I understood earlier that you said, although we consider virtual hearings as a part of oral hearings, we want the consent of the parties for virtual hearing. So if there is one party that says, no, we wanted physical hearings, we don't agree to deviate from that standard normal hearing, what would you recommend to the arbitrator if the other party says, well, but I cannot come because out of health issues? Just to stay the proceedings?
Yeah, I see. But if the condition you mentioned is the parties specifically provided in the arbitration clause says it's an in-person hearing, very specifically, then of course it's up to the tribunal, but to my experience, I would say it's probably that tribunal will follow the arbitration clause, says we schedule an hearing with physical presence. But if the clause does not specifically says it's an in-person hearing, then it comes to, like in my presentation, the tribunal will consider comprehensive factors and then make their decisions.
Okay, so far, probably most clauses will not expressly say that it has to be an in-person meeting, because nobody could foresee the COVID-19 crisis and didn't think that it might be impossible to travel for such a long time. But I think we will have very interesting discussions, not only before the arbitral tribunals, but also before the state courts, because finally they will have to deal with this issue and decide if the arbitrator, by deciding one way or the other, because, well, there's no perfect solution. There will be somebody who will disagree with the solution, and if ever that party loses, there's a high risk that they will try to set aside the arbitral award. David, if I come back to your presentation, is there any other point where you would say there's also a risk that you should think about at least, or at best avoid if we can? No, you have to turn your mic on.
I think the main issues have been addressed. So first of all, it's better to organize everything in the arbitration clause, of course, but as for now, the arbitration clause do not address quite commonly the problem of remote arbitration. And as you said, it may be written that a personal hearing will take place, but most of time it's left to the appreciation of the tribunal, and then of course the national court could control the process in order to see if the decision of the arbitration tribunal is conform to the main principle of arbitration, and the right to be treated equally and the right to be heard. As I said, I think that the right to be heard is not as difficult as one could imagine, because remote hearing, if there are the technical support which is correct, may be as useful for the tribunal as a physical hearing. The main problem is the right to be treated equally.
Okay, thank you very much, David. George, I would like to give the floor to you, because you have already thought about what parties could do now when they are drafting their contracts and are still in a situation where they might anticipate some of the issues that we just discussed and find at least some solutions that will minimize the risk, if not avoid the risk at all.
Thank you, Martin. I would like to thanks again Mr. Su Yong and CIETAC for organizing this webinar. And following the words of my colleagues, I would like to address a specific point about the conduct of hearings. In fact, arbitration hearing remain one of the stages of the procedure most strongly impacted by the health crisis. Because, first of all, because of the inadequacy of safeguards against witness and expert conferring with the counsel. And for example, how to ensure that witnesses are not influenced by the exercise of a testimony. And another example is the presence of a trust third party during the hearing session is the best option. Second point, how to preserve the confidentiality in light of the reliance of technology, particularly in arbitration involving states. And
just George, if I may step in, you were addressing the question of how can we make sure that the witness is not influenced by anyone else in the room, and to have a trusted person there. We just learned from Huai Sun that she said, well, I had a case where one of the arbitrators would have been able to travel to the witness and so be in the same room with the witness and make sure that there's nobody else and the witness is not reading from a teleprompter, but that finally the arbitrator or the arbitral tribunal as a whole decided against it because they didn't want to change the situation for one of the three arbitrators. Who would you consider as a trusted person who could be next to the witness if it's not one of the arbitrators?
It can be a member of a firm of one of each arbitrator. It can be also a person, a lawyer from the other firm, the opposite firm, to be sure that the witnesses and the expert will respect and will be free to express himself. So it's quite easy, but sometimes it can be very difficult to put a third party inside the room. But we've tried that, and there was no, if I can recall, we use just a phone conference, and they were in the same room, both lawyers of the defendant, of the witness, and also one member of the firm, of the opposite firm. So it can work, but you need to have to put people in the same room. It can be quite difficult, but because of a distance, it's quite easy for me to find good people and honest people to be in the same room. And the idea is just to be sure that the witness or the expert will not use some device or notes or something that come from the outside.
If I may just ask, Huai Sun, would that be a solution that would be acceptable, that could have been acceptable in your case, where you finally said, well, I'm not sure it's a good idea to send an arbitrator to the witness, but if the parties would have proposed to say, okay, we take each of us takes a local counsel who is in the same city as the witness, and he just has to sit in the room to make sure that nobody is interfering with the witness. Would that have been a proposal that would be acceptable for you as an arbitrator? Oh, yeah, I will activate your microphone. No problem. I do. Oh. Yeah.
Now,
Yeah.
yes. Yeah. In our case, it's possible for the opposing counsel to send someone to the witness of the other party to observe the situation. So that has been resolved very smoothly. But I know that in some situations, it might be the case that the witness will be blocked in one area, which will prevent him or her from doing international travel at all. So for that case, I think we will need to rely wholly on the technology to have all angles camera to record what is happening in that room.
Okay, so your solution, George, is approved by international arbitrators. You can try it out.
Thank you, thank you. So, in fact, the main question that I want to address with you is how to make sure that virtual hearings do not lead to the setting aside of the final award. And we have to be clear that the Paris Court of Appeal, nor then the French Supreme Court, did not express their position yet on this very new subject. As Professor Capitan told you, and because of the use of virtual hearings, the National Court during the lockdown, we can assume that awards rendered in France won't be set aside just because the hearings were held virtually. And still, in order to protect the validity of the award, parties and also arbitrators should be very careful on some point. As you may know,
just to give our public the background, because some people might not know, during the COVID crisis, the legislator in France and also the courts decided to have virtual hearings in litigation, where you could say, well, that is even more surprising because there's no consent of the parties to say, well, I would accept virtual hearings in civil litigation. So the argument that could be made is if it's good for normal litigation where party have much more less rights to decide how they want to organize it, then it should be good also in arbitration, right? That is.
Yeah, it's the main idea, but let me explain that in common litigation, you have only lawyers and the court. Sometimes it's one person from the court. And in arbitrations, you can have many witnesses. You can have also many experts. And there is sometimes a lot of people in the room because the lawyers can be 5 or maybe more. And you have the arbitrators, well, in general, 3 person, and you have also the stenotypist and translators. So it makes a lot of people in the same room. And it's very different from common litigation that we have in France, because you have, in fact, 3 persons who are talking. The president of the court, of the tribunal, and also the lawyers, and that's it. It's not if, and I'm not aware about hearing in common jurisdiction with experts and witnesses. The only thing we tried is 3 people at the same time.
I actually did that, but the president was really surprised that I wanted to have the witness testify before him, because he said, well, what's the need for that? So I can understand you say it's culturally quite different, arbitration to litigation. So we have to wait and see how the Supreme Court will.
I think that I think you raised the point at the beginning of this webinar, and to say, someone say, it's quite different when you have a very simple case with few people. It can be very easy to organize a virtual hearing with a simple case and with few people. But it's, from my point of view, quite different if you have many people in the same room or engaged in an arbitration with complex issues, and maybe to produce document during the hearing. So it depends of the case, from my point of view.
What would you have as recommendations for us? How could we make it a little bit safer for the parties to have virtual hearings?
I just want to maybe there is 3 steps to be sure that, or 3 ideas to be sure that the hearings will go fluently. Before the hearings, during the hearings, and after the hearings. First of all, before the hearings, I think that we have to make sure that both parties, first of all, agree on virtual hearing and how to organize the hearings. Indeed, a party who do not agree to a virtual hearing might argue that he had not been afforded a full opportunity to present its case for various reasons. For example, disadvantaging of arbitrating across different time zones, maybe the lack of stable internet connection. So in order to avoid this argument, it is appropriate for the parties to agree on a protocol that will govern the hearings and that will be signed by all parties. And before the hearings, parties should agree on several detailed rules, such as, for example, ban phones and other devices for the witnesses and experts as soon as they arrive at the hearings, to be sure that the video conference system allows the court to assure that the witness or the expert are alone in the room, or maybe with a third-party witness, and should also the statement can be recorded as an evidence, or maybe to prohibit video recording. We can add that if a party does not agree to a virtual hearing, a tribunal could rule in favor of virtual hearing in case no technical or procedural irregularities could cause harm to the final analysis. So from my point of view, and I think that Professor Capitan told us that, I think that it's better to do not accept a semi-remote hearing, even if you are the party that stand in the same room with a tribunal. So this way of organizing hearing can create a real inequality between the parties and, at the end, endanger the future award. So on this point, my point of view is how to respect a balance. And for that, each party must use a virtual system so that everyone has strictly the same condition of testimony or presentation during the hearings. And during the hearings, what do we have to do? We have to ensure that the oath taken by witnesses and also by experts is appropriate to the situation. And this includes swearing that the witness is alone in the room, that he has no access to his phone, for example, or other devices, or any document that have not been authorized by the procedural order. And at the end, after the hearing, parties should agree on a hearing support subject to present whole parties' contradiction to be sure that anyone will be able to ask for the cancellation of a sentence of the award as soon as it will be rendered.
Okay, thank you very much, George, for your recommendations. I would like to ask Hui Sun on her opinion on these recommendations, if she fully agrees to it, or if you say, well, I would do it slightly different, or there might even be more options on the table. What is your opinion on what George recommended for the parties?
Thank you. I think George's recommendation is very sensible. That is also the equality of the art between the parties. I think that is the most important thing to have these virtual hearings work, and also to ensure the impossibility of the award. And one practical challenge, I think, is always the time zones of different parties. For other things, I think we have better ways to monitor the process. But about the time difference, that is what the natural thing it is. And for the Chinese, yeah.
So for the time zone, what would you suggest would be a good starting time for a hearing? Because we always have that issue that, for example, like for our webinar, we're starting in the morning, you're starting in the afternoon, so you already had a long work day. What would you try to find as a solution for a starting hour for a hearing between Europe and China?
I think for Europe and China, it's easier to arrange. I have already conducted a virtual hearing with one arbitrator seated in London. So the sacrifice he has to make is that he gets up very early so that the hearing can start at 2 o'clock here in China. It still is a very early time in the morning. But from this timing arrangement, the parties will be able to finish the hearing, the whole day hearing, at around like 7 p.m. or 7:30 p.m. so that there's no need to take a break for dinner or for breakfast. So that is something that we can make it happen. But I think in a lot of cases, if there's an additional party or counsel or witness who is located in another time zone, for example, in our case, that is a witness, he is located in the US, so that makes things that more difficult to adjust to his time zone. And for the two opposing sides, if putting aside the arbitrator, because the arbitrator it's a personal sacrifice. But if they for the whole team, I think it will be more difficult to coordinate the timing. But so sometimes I heard the stories that somebody has to get up like at 2 or 3 p.m. 2 or 3 a.m. to be present at the hearing because he is the only counsel located in that time zone. So that makes things that very tiring, especially if the hearing lasted for several days. So you need to adjust to this schedule for a long time. So it's I think it will affect to some extent the coordination and the preparation for the hearings if the parties, counsel, and also the party witness, they are located in different time zones. That's a very difficult issue to be resolved.
That might be a very important point, and that might be a good advice for Mr. So Young, because if you provide for facilities in Paris, that means you also have to make sure that they are working at hours when it is can be synchronized with China or the US, because if they say, well, we open up at 9 o'clock in the morning Paris time, that makes it difficult to start the arbitration at noon or even at 2 o'clock Beijing time. So sometimes it's very simple things can have a very strong impact on the arbitration and on the life, especially of everyone involved, and create more stress, and might be a reason why then there are more conflicts about smaller issues that finally lead to the challenge of the arbitral award. So I think it's important for everyone to be aware of these issues at best at the moment when you're already drafting the contract, but we all know that, well, you cannot foresee all situations. So maybe at the moment when the parties first get together or virtually get together, that should be the moment when they think about how to organize the arbitration and the virtual one, and think about all the obstacles and problems and try to find a solution before they face it. We have now used 2 hours, not only of our time, but most of all of our public. And I think it has been a very rich discussion, although I didn't stay completely to the order of the presentations, but I was so curious about, and it was so great to have the different perspectives of arbitrators, experts, councils, the institution, CIETAC, that it would have been a shame not to use this power of different perspectives to get directly the most important advices for the public, because they might be the ones who use the arbitration. And finally, we do it all for them. They should not only hope to get a good award, because there will always be a losing party in an arbitration, but also feel comfortable and secured about the way this is handled, because that can sometimes bring peace to people when they feel that they had the chance to be heard, that they were treated fairly by the arbitral tribunal, that their witness was in a position to testify as good. I think it's a lot easier than for the losing party to accept an award as if they had the impression that there was one party that was favored not by the arbitral tribunal, but just by the situation, by the fact that they were in the same country. So I think that is what we talked about is very important for arbitration as a whole to be accepted. I would leave the floor to Mr. Su Yang to say some last words, because it's thanks to CIETAC that we have this great China Arbitration Week with lots of different webinars going on. We hope that next year we can come to China and meet physically and have some discussions there, because, well, as Ann-Karin said, it's more difficult to connect with people if you only see them on the screen, although I had the impression that during our webinar we well connected, and that is also a reason why I would say that give virtual hearings a chance. It's maybe not the same and as perfect as a physical hearing, but it's still a good solution.
Okay, I want to thank you for joining us for today's webinar, which is part of a series of the events organized by CIETAC for this year's China Arbitration Week. I hope you find new ideas on virtual hearings or non-contact arbitration and its legal challenges. Thank you again, everyone, and I wish you have a good day. Thank you.
Thank you very much. Have a nice day. Bye-bye from Paris.